Heard counsel for the petitioner. This is an application filed under section 11(6) of the Arbitration and Conciliation Act 1996. So the petitioner and the respondent entered into an agreement executed on 13th day of January 2016. So the said agreement contains a clause where it is stated that in cases of any disputes between the parties, the matter shall be referred to arbitration. Stop the said clause. Containing the arbitration clause is at clause 47 of the agreement. Stop pursuant thereto, disputes and differences arose between the parties, and the same not having been sorted out, the petitioner invoked the arbitration clause and issued a notice dated 8/3/2025. This calling upon the respondents to appoint the arbitrator named in the said notice. How many notices you sent? One, sorry, not 8/3, 21/5. 21/5, huh? However, the petitioner did not, the respondents did not accede to the request, the demand made for appointment of an arbitrator. And objected to the appointment, unilateral appointment of the arbitrator mentioned in their notice. Stop. Consequently, this section 11(6) application has been filed, praying for appointment of an arbitrator. Issue notice, returnable 4 weeks, steps on respondent by registered post AD as well as usual posts. You want to take Dusty? Yes. Dusty is also permitted, provided it is routed through the office of the routed through the registry, the list accordingly.
Highly lovely.
If there can be, I can pay.
Yes.
In this matter, on the last occasion, your lordship has passed an order directing the respondents to appear personally if they have not taken anything. I have not considered the matter. It was a long order, your lordship has passed. Considering everything, they're being asked to appear.
Lordship, in persons of earlier order, my lord, the regional director is present before this position.
Where is that order of disengagement?
Yes, this again is going to finish now.
Where is that order?
That
Where is that communication?
That communication, your lordship, will be at 366. 66. Yes,
Yes. Yes.
Your lordship, assistant director is in person.
We asked for the regional director, I
He
think.
is also there. He is also there.
Yes.
Yes, sir. The mayor submit.
What is the, yes, tell us.
First is the regional director has acted on the direction of the assistant director, Noida Regional Center.
All right.
So now regional center, he has been just directed that yes, you need to disengage the concerned casual employee. Now, why we have acted? So this has no relation with the direction passed by this order in 2017.
Hmm.
Subsequently, in the year 2018, there was an FIR by CBI. So thereafter, CBI has given us a self-contained note, which was never filed before this court. We have this in our, will not give it to you. So after that, when there was a direction along with him, 4 to 5 other employees of NIS have been removed from the services. 2 were permanent employees.
According to you, if an order of the court is issued,
Please, Your Honor.
it is subject to such other orders as may be issued by the investigating authority, departments.
Please, Your Honor.
Is that what you're trying to tell the court?
No, sir. No, sir.
Once an order of the court is issued,
Yes, sir.
you are required to comply with it. What is your name?
Sir, Lordship Milan Laskar. Milan Laskar, I am the counsel for NIS.
That we can see.
Please,
But before being a counsel, you are also an officer of the court.
please, Your Honor.
So therefore, it is your duty as a counsel to
Yes.
explain
Yes.
how the orders of the court are to be implemented
Please, Your
and
Honor.
the consequences thereof
Please, Your
for
Honor.
not implementing it.
Please, Your Honor.
Perhaps there was some shortcoming on your part
Please.
in conveying this to your client. Once
Your-
an order of the court is passed,
Please.
it is not for you to decide whether CBI will give you permission to implement it. If you have difficulty,
Please.
it was open for you to file necessary application before the court,
Please.
get the order modified.
Please.
Did you advise that to your client?
Lordship, at that point of time, I was not the counsel.
Who was the counsel?
Uh,
When you received the instructions to appear on them, was it available to you to understand that this order of this court has not
Please,
been
Your Honor.
complied with?
I, on my personal ground, I have asked them repeated times just to clarify. So now the clarification is that we have the ordinal office note also. Why this order was that?
We are not interested to know why this order has this
Please,
order
Your
been
Honor.
modified by a high court?
Please, Your Honor.
Is this order being modified by a higher court?
Please, no.
No. So unless it is modified recall, this order has to be complied with.
Please, Your Honor.
What steps have you taken to bring it to the notice that the reasons why this order could not be complied
This
with?
was the miscommunication from the regional center and the headquarter. So that was the reason there was a miscommunication. Apart from that, but this was done on, there was
We are not interested in what communication, what miscommunication.
Please,
We are asking you because you have entered appearance in this matter.
please.
What steps are you going to take now to ensure the compliance of this order?
As per the wisdom of this court, whatever the order this court we will follow this order.
This order is already there.
Please, Your Honor.
This
Please,
order,
we'll follow the order.
we don't require orders in sequel to ensure these earlier orders need to
We
be
will
complied with.
comply with the last order.
It is for you to decide what proper steps you are the counsel you are
Please, sir.
supposed to advise your clients.
Within 4 weeks, we will take all necessary actions, sir. Sir, can we just, for our own this one, can we just put into record that there is a CBI case and still
Are you asking legal advice from the court?
No, sir.
When did you join practice?
2012,
2012.
please. So
It's been 13 years and you're asking for legal advice from the
No,
court.
this is calling from your side. My apologies.
We should refer your case to the Bar Council to decide whether your license should be carried on or not, extended further or not.
My apologies, sir.
Your apologies are meaningless. You are an officer of the court. You come and assist in administration of justice.
We will do the needful, sir. We will comply with the court orders.
We'll give you time till Friday. You
Yes.
come and apprise the court what steps you're required to take. Yes, you are the assistant director. What is your name?
My name is R. Bhaskar.
Please come forward. There was an order passed by this court. I do not know whether you are aware or whether anybody advised you. You are required to carry out the orders of the court. If you have difficulty, you are required to take steps to bring it to the notice why this order could not be carried out. That was not done,
Thanks.
right?
Yes.
So we are giving you time till Friday to rectify that and apprise the court what steps you want to take.
Hi, Lord.
Mr. Manan?
No.
this matter on Friday in deference to the earlier order
Friday,
dated
I
so and so.
we don't-
What is your name?
Milan Laskar,
Mrinal
Milan Laskar, MILAN.
so and so Laskar, counsel representing the assistant director and the
Friday is
regional
And the
director.
regional director.
Lordship, Friday is a holiday.
I am on behalf of assistant director. Assistant director till now, not responded to me, not neither communicated over phone or physically. All of us, I saw him just inside the court.
Friday is
Mr.
holiday, Your Lordship.
Laskar appears on behalf of
Holiday.
the respondent assistant director. The learned CGC submits that in spite of instructions been sought for, there was no response coming from the officers of the NIOS. Stop. Accordingly, this court considers it appropriate to permit the respondents to take all steps necessary in deference to the order dated 24/5/2017. Stop. The respondents, assistant director will apprise the court on Thursday. We'll give you time till Thursday because Friday is a holiday. Then you apprise us what steps you want to take.
Your Lordship, and indulgence that his appearance may be dispensed because he has to come all the way from Delhi. We will do needful and we will apprise the court, sir.
You come on Thursday. After that, we'll decide. Thursday.
Hello.
List again on Thursday.
Okay.
The question of dispensation of personal appearance of the officers will be decided on the next date fixed.
Hello. Obliged.
Below similar matters, Lordship has already issued notice, Miller.
They fall under which category? One or two?
One, Miller.
One.
Yes. And your Lordship's order is at page 188, Miller.
So this 164
Yes.
is the order of the division bench, judgment of the division bench.
Yes, 160, yes,
So you say you fall under 1-1.
yes.
Yes, Mr.
Well, the Lordship has issued notice in the similar case. We'll file our affidavit in the matter that Lordship may issue.
Oh, and where is the impugned order?
Impugn order is at page number 168, Miller.
168.
168.
168. Heard, learned, Mr. K. N. Chaudhary, learned Senior Counsel, assisted by Mr. J. Patwari, petitioner. Mr. Learned Senior Government Advocate appearing for the state. This petition is filed by the petitioner, aggrieved by the impugned order dated 21st of July 2025, whereby the petitioner was discharged from service with effect from 7/9/2018. No, sorry, discharged from service, who was earlier discharged from service with effect from 7/9/2018 by the notification number AAP 91/2018/60. Stop the earlier notification by the impugned order. The earlier notification stands substituted. What is the meaning of this?
Which one, Miller?
168.
Now therefore, governor in exercise of power conferred under rule so-and-so is pleased to discharge this so-and-so with effect from 7/9, that is the date of discharge given by notification, which stands substituted as directed by the honorable High Court.
So this discharge is now with effect from 21/7.
And this earlier discharge will be interpreted.
Actually, Miller, The earlier discharge order doesn't stand anymore.
Set aside.
That way also is another ground, Milord.
How can it stand substituted? Stop. Learned senior counsel submits that this impugned order is totally violative of the directions contained in the judgment and order dated so and so, passed in WPC number so and so, another bunch of writ petitions, where the writ petitioner, WAN, not writ petition, writ appeals.
Writ appeal.
Was he also an appellant?
Yes.
What is the appeal number?
Writ appeal number, Milord. Give me a second. Once I'm giving, Milord.
Where the present writ petitioner was also an appellant. By the said judgment and order, division bench of this
Sure.
court allows the writ petitions, writ appeals with the following directions. Page number 164, para 140, strict. Para, it is the submission of the counsel with the petitioner that the present impugned order dated 21/7/2025 is completely violative and with utter disregard to the directions contained in the judgment and order dated so and so, passed by the division bench. So therefore, being agreed, the present writ petition has been filed. The senior government advocate submits that at this stage you'd like to obtain instructions. However,
Lordship, the order was passed
He-
following,
he submits that the impugned order, which is the order which is impugned in the present proceedings, is in terms of the directions contained in the judgment and order dated so and so, passed in writ appeal number so and so. Consequently, there is no infirmity in the orders passed, and therefore no interim orders are called for. Having heard counsel for the parties, considering the issues involved, at this stage, the court considers it appropriate to issue notice. Accordingly, let notice issue, returnable 4 weeks. The respondents are represented by Mr. Das. By the learned senior government advocate. All the respondents.
all, Madam. 3 respondents are there.
Therefore, notices are waived, extra copies be furnished within a period of 1 week from today. Till the next returnable date. Are these matters fixed on a particular date?
Lordship, it was fixed.
Earlier it was fixed, but on that day, Honorable Justice Manichori did not take up the matter. Therefore, no date has been fixed. Na?
It is fixed after 1 week.
No date, Milord.
It will come after 1 week.
Till the next date of listing, Milord. Or as your lordship pleases.
Lordship, may give a date until then.
Till the next date of the stay.
Side target to know, na?
15th October,
Lordship,
the impugned order shall remain state.
Lordship, page 189, Lordship has said that it will not be given effect to. Similar,
Are
same
not be given effect.
order may be, same order may be there.
Para 20.
Milord, writ appeal number is 101 of 2020.
You give the numbers.
So what I'll do, Milord, we'll give the numbers.
You give the numbers.
Yes, yes. My junior will give the number to her. My lord, 3 and 4, the discharge order will change to 3 and 4. Item number 3, my lord, the discharge order is 28/7/25.
All right.
I mean, item number 4, discharge order is 27/25.
20.
20.
And item 2 is 21.
Item number 3, page 160.
No, item number 2 is
2 is by personnel department,
21st.
21/7.
22nd.
And
And-
this is 28/7,
Item number 3.
3,
Yes,
page 160,
yes.
by labor department, labor welfare department.
All right.
Mala, item number 4 would be 27-7, not 27. 27-7, 25, page 162.
Finance.
27.
And this is labor. Sorry, it will be sales tax.
All right,
It does no.
all right.
April. Mala, my junior will give the retail
Yes,
number.
yes.
For others, item 5.
May I please, Your Lordship? Lordship, this is, as this is a part heard matter and Mr. Roy is out of station, let this matter come up either tomorrow or again on Thursday.
What is this about?
My lord, the petitioner was dismissed from service.
Back
That is-
wages.
Yes, my
Wages,
lord.
back wages.
Dipali Gundu.
Yes, also my lord, new one has come, FR 54.
Hmm.
Thursday, my lord.
Thursday, all right.
Thursday.
Thursday. As agreed
All right.
by the council for parties, list on Thursday.
Also,
Item 3.
And appears, what is this?
Okay,
Anything survives?
the petitioner retired, my lord. 5 years ago, he retired, my lord, and this is about promotion, my lord. So it is naturally infectious. My lord.
None appears for the petitioner on call. Mr. A. Borthakur appears for the respondent. Forest Department. matter
PhD,
stand-
my lord.
PHE.
Yes.
Matter stands passed over for the day.
Problem.
Double.
In this matter, my lord, respondent has submitted their affidavit,
Hmm.
and after that, my lord, I tried to communicate with the petitioner, my lord, but
Hmm.
for last 4 to 5 years, I am unable to.
What do you want to do?
My lord, may dispose of the matter as per instruction of the respondent, my lord.
What instructions?
But they have submitted that.
Respondent 5.
Respondent 5, my lord.
5 million RPX, provident fund.
So what have you stated?
Well, we have paid the.
Accumulated contribution.
And salary, pension of rupees 58, page 2, my lord, paragraph.
Hmm. So you have paid EPF and
Area pension also.
area pension you have paid.
Getting.
Paid or not paid?
My lord,
Paid or not paid?
paid.
Paid. And he is getting his pension at the rate of 12,
One,
27.
yes, my lord, per month.
Heard, what is his prayer in the writ petition? Retiral benefits.
Retirement benefit.
No, then we'll have to say that you are accepting this calculation. Your claim in the writ petition is 18 lakhs. Then 9 lakhs. Then unutilized leave salary. And so if they according to them, they have paid whatever is stated in para 2, page number 23. If we have to close it, then we have to say that you accept this calculation.
My lord, but for last almost 4 years,
It heard learned counsel for the parties, the petitioner before this court is a former employee of the Assam State Transport Corporation. You are representing whom?
Respondent number 5, my lord, provident fund.
Provident Fund.
Yes, ma'am.
What about Transport Corporation?
On a comment for the ASTC is the main respondent.
Who's for ASTC?
Nowadays, HMOA. Okay, then he has to. In this matter, I don't think.
Where is A Chamua? Please inform A Chamua. We will call it up after a while.
I'll
Please inform me. Yes, order complied?
Lordship, order has
No,
been
my-
complied with Lordship. I have filed
Order
affidavit,
has
Lordship.
been complied with, my lord.
Complied,
Complied,
No,
Lordship.
my lord.
not
My lord,
complied.
mother died on, my lord, 17/10/2018.
Where is the order?
Yes, Lord.
First.
Order Lordship will file at page 9, my lord.
Hmm. Directions?
Direction page 19, my lord.
Paragraph 33 is Lordship. Reading.
And what is the order you have passed?
Yes, Lordship. I have filed affidavit, Lordship. Kindly peruse page
My lord.
28, Lordship.
Page,
The mother,
28, running page.
mother died on 17/10/2018. She
one
have-
minute, one, page number
28, my lord, running page.
28.
Paragraph 4, my lord. Direction was, Lordship, in that view of the matter, discourtesy of the view of the petitioner who is divorced daughter and was dependent on her deceased mother is entitled to the family pension, subject to the condition that authorities may satisfy on the dependency factor by incorporating additional queries as may deem fit and appropriate. And Lordship, then Lordship, our paragraph 4, Lordship. It is stated that after receipt of the unmarried daughter's pension case as well as dependency factor from the Administrative Department, Government of Assam, the Office of the Deponent has authorized the family pension payment order bearing number so and so, and subsequently revised family pension payment order author so and so, addressed to the Treasury Officer Jorhat to make necessary payment. And copy was also sent to the petitioner in her home address through post. It is pertinent to mention that the pension is applicable with effect from 30/4/2019. That is from the date of application in terms of government notification dated so 9/8/2018, Lordship. So order has been
What is
complied
that,
with.
what is that government notification?
Yes, Lordship. Government notification is, I have not annexed, Lordship, but there is a notification, Lordship. So Lordship, if Lordship, he is entitled, he has to challenge that, Lordship. Because their
What is
direction
that
was to pay the
notification?
family pension, Lordship.
What is that notification? Are you aware, Mr. Sogia?
No, my lord. That is
Government
what I was-
notification. So ultimately, what have you done? You have released the pension?
Yes, yes, Lordship.
From the
Release
date of application, not from the date of death of the mother, my lord.
Hmm. So there was a liberty granted for you to verify whether she was dependent.
Yes. And accordingly, we have verified and entitled and we have authorized the
So you show us that notification. What does it, what does the notification say?
Lordship. Next that I will bring, Lordship. Bring, Lordship.
You see if you can get it by the second half, we will examine and
Lordship.
pass an
Lordship.
effective order. What is this? Huh? At 2 p.m.?
My lord.
Pull up at 2
At
p.m.
2 p.m., my lord, another matter is fixed, my lord. Costing me
Hmm?
At 2 p.m., my lord, another matter is fixed, my lord.
We want to see that you ask
Sir.
your colleague to be present here.
My lord.
See.
Oblige, my lord. Again, my lord.
Yes.
Lordship, today it is listed because I want to strike out the name of respondent number 2. Lordship, Lojima order is there, who is a performer respondent. 2625.
I also have a prayer, so I'd like to file an affidavit and some instructions. So some time, 2 weeks time. Puja Piti.
Who is respondent to?
He is an officer of respondent number 1. But they were, both of them were made party respondent in the tribunal, but here it is referred by, so,
This is you're challenging what order?
yeah, order of industrial tribunal.
Industrial tribunal. Filed by the respondent number 1.
Yes, Lordship.
What do you have to piece of?
Okay, respondent 2 is anyway pro forma respondent.
Yes, yes.
Huh?
But unless the name is struck off, it will always come up for, it will not come up for admission. So I asked the Lojima court, but they just pass the order and say,
Yes, Mr. Mannan, any objections?
No, I don't have objection with regard to that. Only I have to take the instructions and file affidavit
For?
the respondent, the first respondent.
No, regarding the prayer that number 2 may be struck off.
Number 2, actually, they have to strike, if they struck it off, that will be at their own peril.
No, they want to be struck off. Is there any objection?
I
from your
don't have
side?
any objection.
Heard. That is B. Sharma, learned CGC, appearing for the writ petitioner NF Railways. The prayer made before the court today is that the respondent number 2, namely so-and-so, who was arrayed as pro forma respondent, may be struck off, as the NF Railway has not claimed any relief against the said respondent. Stop the present proceeding. He is putting a challenge to the, is it an award?
yes.
Award dated
16/11/21.
award dated 16/11/21, passed by the Industrial Tribunal, Amrup. I'm sorry, Central
Yes,
Central Government Industry.
Central Government Industrial Tribunal,
from labor court,
come labor commissioner.
presiding officer.
All right. In reference case number 06 of 2019. So prayer made is not objected to by the learned counsel appearing for the respondent. Accordingly, respondent 2, pro forma respondent's name is struck off from the writ petition. Stop. Matter be listed again for admission. Meanwhile, as prayed for by the counsel appearing for respondent number 1, liberty is granted to file affidavit. Matter be listed again on 27th October.
There's an interim.
The interim order passed earlier will continue until further orders.
Obliged.
Item 11.
May it please your lordship. If in this matter, service has been completed. Service is complete.
Service complete.
Lordship. Automatic hearing.
Service in the writ petition is complete in terms of the notices issued earlier by the court. Matter therefore be listed for admission. MS so-and-so appears for the respondents.
Oblige your lordship.
Item 12.
May I please the Lordship? Lordship, affidavit is not filed, Lordship. Kindly see the last order. Lordship, affidavit is sent for vetting. Yes, sir. But Lordship,
Learned counsel appearing for respondent.
respondent number 1, 4, and 6.
One.
Lordship, respondent number 1 and 4 has already transferred.
You on whose behalf are you filing the affidavit?
Lordship, 6.
On 6.
6. Lordship.
Submits that the affidavit on filed by the respondent. Affidavit on behalf of respondent 6 will be filed within how much time?
Weeks time, Lordship. 2 weeks time.
2 weeks. Accordingly, She submits that the matter be listed after 3 weeks. MS so-and-so appears for the writ petition. I'm sorry, the contempt petition. List again after 3 weeks.
14.
My order is at page 26.
Uh,
As per Upendra's minimum salary.
Respondent 2, notice is not served. Respondent 2,
My lord.
you are appearing for all the respondents.
Yes, my lord, 1 to 4, but 2 is not existing. My lord, Soil Conservation Department has taken steps to comply, but because of a finance department's obstruction in the form of sunset clause, it has not become possible. My lord, may I place this or lordship present?
Have you complied with the order or not?
Because we took steps to comply with. But finance department, there is a rule of finance department, sunset clause. That is
Rules
because-
for finance department, who's there? Finance department, standing council, wait, let us have the finance department.
Yes, fine.
Item 14, no? Hold up. No, which is? Hold. Yes, Mr. Ali.
May please the Lord. Lord, as per office note, my lord, 11/6, my lord, service is completed, my lord. And no affidavit has been filed by the respondent.
I'm appealing for respondent number 5, my lord. Receive copy for weeks time may be granted to file an file.
4 weeks.
4 weeks, my lord, some fraud date, my lord, because.
Stay order is there.
No, no,
that's called.
So in view of the holidays, it will come after the holidays only. So I think we can grant him 4 weeks' time.
Proceed date may kindly be fixed, my
Date.
lord.
Mr. R. Ali for the petitioner, Mr. A.K. Dotto submits that he is entered appearance on behalf of respondent
5,
5,
5,
only 5.
only 5.
He submits that 4 weeks' time be granted for him to file the affidavit. Accordingly, let this matter be listed on 16th of October.
Well, it's state respondent is the implementing agency, my lord.
We don't know, he recorded your prayer. If you want to file,
Yes, my
we recorded it. Let us see. 16th October.
This is the second round of litigation, my lord. One affidavit has been filed. The other 2 companies have not filed their affidavit. Now, I pray, my lord, your lordship may kindly fix the matter for hearing. Because these 2 employees, my lord, they have been deprived of their ROP benefits, 2007.
APG.
Second round.
For the respondent number 3 and 5, I am appearing. I am awaiting the instructions from the respondents a lot. I need some time to file the affidavit in the matter.
More than 5.
Two petitioners belong to APGCL, my lord. Petitioner number 5 and petitioner number 7. Others are from the other companies, my lord.
So is it against the APDCL or GCL?
APDCL, they have 4 employees. 1, 2, 3, and 4 are from APDCL. 5 and 7, petitioner number 5 and 7 are from APGCL, Power Generation Company Limited, and petitioner number 6 is from AEGCL, my lord.
The AGCL has already filed affidavit. Same contents will come because grievance is same.
No, without the instructions, it is difficult
How
on my
much
part. to
time do you
tell.
require?
Lordship may give us 3 weeks time. My lord. We will try to file the affidavit before the vacations, my lord. And after the vacations, my lord,
Not may fix the date after 4 weeks or 5 weeks.
Right. Mr. B.D. Das, learner senior counsel, assisted by Ms. So-and-so, yes, for petitioner. Learned government advocate. You are standing counsel.
Standing counsel, respondent number 3 and 5 for standing counsel.
Mr. D. Nath, learned counsel appears on behalf of respondents,
Respondent number 3 and 5.
3 and 5. Anyone else?
Yes, sir, Lordship. Respondent number 1, 4, and 7 for APTC.
Mr.
C. Paul.
C. Paul for respondents, 1, 4, and 7. 7. And Mr. S. Kotoki for
2 and 6.
2 and 6.
2 and 6 are filed affidavit.
Mr. Kotoki submits that the affidavit on behalf of respondent 2 and 6 has been filed. Mr. Nath prays for 3 weeks' time to complete his instructions and file necessary affidavit. What about Mr. Paul?
Instruction error dates.
Mr. Paul also prays, makes a similar prayer. Let this matter be listed on 13th or 13th
May not be on 13th. Lordship may go after a week, my lord.
after 1 week.
Lordship, that's it.
Then 27th. Let us have it on 27th.
Lordship,
Admission hearing.
lordship,
For admission here.
lordship.
You file.
My lord,
You don't file, we go ahead with the whatever material is there.
well, we'll, before that, we'll,
Matter be listed for admission hearing.
lordship.
The attempt will be made to dispose of the petition. In the event the affidavits are not filed, attempt will be made to dispose of the writ petition on the basis of the pleadings available already on record.
Published.
Recording.
Please.
Item 17.
Well, this IA is for correction of an order, typographical error, my lord. The
Oh,
order starts at page 10. Lordship may come to page 13, last page.
yes,
Lordship is that under such circumstances, Lordship has got it, my lord.
yes.
That third line, my lord. Under such circumstances, it is now clear that the respondents are required to comply with the directions contained in the order dated 11/8/2023 passed in WPC number so and so and other connected with petitions, and to regularize the services of the petitioners with effect from 10/6/2023. Lordship, in our case, the services were already regularized with effect from 10/6/2003. The Lordship, in place of this, if your Lordship, what Lordship will, that is, will decide. But the thing is that this will create some complications, my lord, to
Where
regularize.
is that order of 11/8?
Lordship.
11/8?
11/8 is with the contempt case, my lord. It is with the contempt case. There was a direction to dispose of them.
11/8.
Page 9.
This is the division bench order you're referring to? No.
No, it's a single judge's order, which has, against which the contempt case has been filed. Division bench is in the IA we have filed. Division bench order is in the additional affidavit, my lord. Filed on 10/6/25 at page 72.
What was your writ petition number?
Writ petition number WPC 4506 of 2018.
No, you are referring to the direction at page 33.
Lordship, page 33.
Page 33.
Here, my lord, in the Lordship's order at page 13, it has been written at 23, 10/6/2023.
No.
In the IA, my lord.
No. IA we know.
Yes.
In the IA, there is some reference of an earlier order.
Yes, the division bench order.
We don't know. What
There
is
is a
this
division bench order, my lord.
11/8/23 is passed in WPC 4506.
Yes.
That is a division bench order.
That is single judge's order. And similar against a similar writ petition.
You come to para number, second para or the first para in page number 13.
Lordship, that order, Lordship will find at the additional affidavit filed by the petitioners at page 72.
Of the contempt petition.
Of the contempt petition. Now. It starts at page 71. Additional affidavit filed on 10/6/2025.
Deepak Hazarika.
My lord.
Okay. Then where is that order?
Page 71 it starts. IS civil number 237 of 2025, and the direction is at page 72. My lord.
Wait, 10/6/2003
3.
instead of 23.
Yes, and one more thing, my lord, already they were regularized, my lord. Therefore, my lord, if your lordship say that by taking the date of regularization with effect from 10/6/2023 will suffice, my lord. Because again, if they have to be regularized, it will create some complications, my lord, because their services has already been regularized.
What is your claim in the writ petition?
Or to pay pension under the old pension scheme, because their services were prior to coming into force of the new pension NPS, and that was allowed.
No, there is some confusion somewhere. Where is the order dated 11/8/23?
11/8. 11/8/23 at the contempt case, lordship will find at page 9.
Yes, page 9.
Page 9. It starts, my lord. There were a number of writ petitions tagged together. Then, my lord, the order starts at page 29 from the bottom part. And the direction effectively at page 33, paragraph 10.
And what is your writ petition number here in this order? Paragraph 11, what is your writ petition number?
Paragraph 11. This order is. Well, this 4506 of 2018.
Right, heard. Learned counsel for the petition and this IA has been filed seeking correction in the order dated 13/8/2025, passed in contempt case number 279 of 2024. So there are the contempt case number 279 of 24 was filed by the petitioner alleging willful disobedience of the directions contained in the judgment and order.
Eleven eight
11/8/2023, passed in a bunch of writ petitions, including the writ petition number
4506 of 2018.
06 of 2018. Stop. These writ petitions came to be disposed of by placing reliance on the order dated 5/8/2023, passed in writ appeal number 133 of 2023, affirming the order dated 5/8/2022, passed in WPC 4397 of 2022. Stop. The coordinate bench held that since the order dated 5/8/2022 passed in 4397 of 2022 stood affirmed by the division bench in writ appeal 133 of 2023, all these writ petitions were required to be allowed, directing the respondents to pass appropriate orders against the entitlement of Gaon Panchayat secretaries to pension under the Assam Service Pension Rules 1969 by taking note of their respective dates of regularization. Stop. It was ordered accordingly, and the writ petition 4506 of 2018 also stood disposed of along with other writ petitions in terms of the said order. While closing the contempt petition,
But the lottery contempt was not closed, it was listed, directed to the list of the-
while passing the order dated 13/8/2025 in contempt case number so and so, in page 13 of the said order, it was directed as under a mark kora portion to extract puriva italic sub. Page 13. Sorry, not page 13, page 4. Page 4 of the said order, it was directed as so and so. Stop. Where upon perusal of the papers and upon hearing the submission of the counsel for the parties, it is seen that the said paragraph was wrongly recorded, and accordingly the same stands corrected. Stop. The petitioners were already regularized with effect from 10/6/2003. Therefore, the respondents are now required to take into consideration, are required to comply with the directions contained in the order dated 11/8/2023 passed in WPC 4506 of 2018 by taking into consideration the respective dates of regularization of the writ petitioners, of the contempt petition. Stop. Para. The order dated so and so. Order dated 13/8/2025 accordingly stands corrected. Stop. The order passed today in the IA shall be read together with the order dated 13/8/2025 passed in contempt case number so and so. IA accordingly stands allowed, disposed of.
And deeply obliged.
The instant intellectual application has been filed for substituting the name of the legal heirs. During the pendency of the connected writ petition, Your Lordship, the petitioner had expired.
Who's for the respondent? Any objection?
No, madam.
Heard. The counsel for the applicant. This IA has been filed seeking substitution of the legal heirs, namely the appellants herein. It is submitted by the learned counsel for the applicant that the writ petitioner who had filed WPC 1995 of 2024 expired during the pendency of the writ petition. Stop. The writ petitioner expired on
Your Lordship,
8/5/2025. Stop. Leaving behind the present applicant, number 1A, as the widow of the deceased, and 1B as the son of the deceased. writ petition, no, stop. Both are residents of so-and-so village, paragraph 3. So being the legal heirs of the deceased writ petitioner, this IA has been filed seeking implement, say substitution in place of the present substitution in place of the deceased writ petitioner. So Mr. R. Dhor, learned government advocate representing the PWD.
Well, PWD man.
And Mr. B. Chakraborty representing accounting general does not object to the prayer made for substitution. Stop accordingly. The I stands allowed in terms of the spirit of Order 22 Rule 4 CPC 1908. The applicants stand substituted as petitioner 1A and 1B. In place of late Ghanshyam Bhuya. So the applicant will file amended course title before the registry within 2 weeks from today.
Minor.
And the matter be listed thereafter. I stands allowed, disposed of.
Obliged.
May I please, Your Lordship? Lordship, Mr. Soma is out of station for recruitment, Lordship.
You get instructions in rest. Do you have an extra copy of the petition?
I can submit.
You serve. You get.
And Lordship, our name is not reflected in the cause list also. Lordship.
Kindly hear the order of the court first. You understand what you're required to do. This writ petitioner is claiming pension.
Lordship.
The amount is quantified in the writ petition, also mentioned in the prayer. The you are representing whom, Mr. Chakraborty?
Respondent number 5. Provident.
Provident Fund has filed an affidavit quantifying certain amounts already released.
Lordship.
Now from ASTC, you have to tell us whether any other amount is pending
Lordship.
and what steps will you take to release the same. We are listing this matter again on 22nd of September.
Lordship, 22nd, maybe Mr. Soma will be out of station, Lordship.
When is he going to be in station?
Lordship, after Puja vacation.
No, this is a pension matter. You have to get the instruction somehow. We want to close it 2018 matter.
Then Lordship,
Before that?
Before 17th,
15th?
Lordship.
15th of September. All right. List this matter again on 15th of September, including the Standing Council for ASTC
Lordship.
to complete their instructions. Council for the writ petitioner as well as the Council for Provident Fund.
Yes.
Undertakes to serve a copy each of the pleadings to the learned counsel appearing for ASTC.
Right, respondent number 1, madam.
MSMD Bora for respondent 1. Have you filed any affidavit? No.
I'm a formal party here only. Because
All right.
obliged. If I will also get instruction.
Yes, yes,
Okay.
please. What is this?
Lordship, this is an application for seeking compassionate appointment, Lordship. On last occasion, Lordship has directed me to obtain instruction, Lordship, whether the case of the petitioner was placed before the SLC or not, Lordship. So my instruction is that, Lordship, because the personnel department has been made party, so I have taken it up with them. But they have stated that they are not a member of the SLC, Lordship, so they have no information. I think, Lordship, the PH.
Who has passed this executive order? So
Yes, Lordship, this is the new order that has been
This is issued by
issued by the personal department,
Personnel
Lordship.
Department.
Yes, Lordship.
So what is the procedure prescribed here?
Lordship, this is regarding the applications which has been decided as per order dated 3/4/2025, Lordship, the common judgment and order. So they have sought for an application. The persons who have challenged this OM, Lordship, last OM of 18/9/2024. So they are supposed to apply for the post. And those Lordship have not challenged this Lordship. Their cases has to be dealt in terms of the OM dated 18/9/2024. And there is another direction, another criteria there, Lordship, to look into considering and disposing of the case of compassionate appointment. Lordship, the first criteria is the immediacy in determining the claims for compassionate appointment. And that.
No, this is already there.
Lordship.
The controversy arose because of your 18/9/20.
18/9, Lordship, yes.
Now, in view of 18/9/24,
Lordship.
cases which were recommended by the DLC
Lordship.
were also not considered.
Yes, Lordship. So, as
The 18/9/24 is a blanket order not to go
Lordship.
for any
Lordship.
further
Lordship.
appointments.
Lordship.
But there it is silent on what happens during the interregnum period.
Lordship.
Because the procedure is followed.
Procedure is followed, but Lordship, there are some dereliction from the procedure also, Lordship, because in March 2017, Lordship, the compassionate scheme was stopped and compassionate family pension scheme was introduced, Lordship. But in spite of that, Lordship, in 19, 20, 22, 23, there are recommendations by the DLC, which is put into trouble for the. This is there. In the present case, this is also so. Death is on 2011, Lordship. And the recommendation is 2022, Lordship. After 11 years.
You see who's for the count state, who's for the petitioner is not here.
Yes, Lordship.
None appears for the petitioner. MS M. Bhattacharya, additional senior government advocate, has placed before the court the instructions, the executive order dated 30th August 2025, as well as a notice dated 30th August 2025, whereby the government has laid down an SOP for disposal of matters relating to compassionate appointment. Let this matter be listed next week.
Deeply obliged, Lordship.
Okay.
This case is regarding pensioner benefit, no?
We are claiming your lordship pension and pensionary benefit. The petitioner retired on superannuation on 30/11/2022. Still date, your lordship, now it has not been paid as per the Guwahati Municipal Corporation Pension Regulation 2015. She is entitled.
She is entitled, man. Final calculation is going on, man. How time do we got for disbursement of
5 years for pension.
22.
2020.
5 years.
Some delay here and there, my lord. But the final calculation, accounts department, it is going on, my lord.
We'll have to now start imposing damages on the departments and to be recovered from the hearing officers.
Process has to be done with some part from the petitioner side.
See, even the pension rules say that before retirement,
all calculation
you send the papers and what is the purpose? So that the person.
Here it's our own, my lord. There is a rule for
whatever it may be, but can you merrily go on for 5 years and say we are calculating?
Lots will post it after 3 weeks, but in the meantime, that give the instruction.
Your pension rules, you have a separate set of pension.
2014, separate.
And there is no provision there to say that the person retiring, their pension papers are to be sorted out. Must be there.
Must be there, my lord. There. Also, will post it after 3 weeks, my lord. In the meantime, my lord, most likely that final calculation.
No, you will fix it on 24th. You get the instructions. 24th of September. You get instructions, what steps you are doing.
Lordship.
At least you may ensure that the interim pension, whatever steps you have, you release some amount.
Lordship. Lordship posting on 24th, my lord.
24th September.
Lordship.
Heard Mr. Y. Manan, counsel for the petitioner, Mr. S. Bora, standing counsel, GMC. The learned counsel for the petitioner submits that petitioner is before the court claiming her pensionary benefits for the services rendered to the Guwahati Municipal Corporation. So Mr. Bora prays for further time to complete his instructions, considering that the matter relates to the pensionary benefits. Let this matter be listed again on 24th September, by which date endeavor will be made to dispose of the writ petition. Yes.
Obliged.
Items 21 and 22.
Yes.
Chief, Industries and Commerce Department are required to file their affidavit.
Yeah, basically, our senior government advocate D90 is appearing number. He was here, Lucy, he informed me. So, Lucy, may kindly take up the matter after some time, Lucy.
Because that affidavit has not been filed till now without.
Let him, please.
After some time.
After some time.
Obliged.
23.
May please your lordship. Lordship, I am here on behalf of Standing Council of Animal Husbandry and Veterinary Department. Lordship, government instruction has already been sent. Lordship, only 2 days required to file our affidavit.
Yes.
Earlier occasion also 3 times they.
The council representing the Animal Husbandry and Veterinary Department submits that the affidavit will be filed within the course of this week.
Lordship.
And accordingly, matter be listed again on 15th. The petitioner may file rejoinder affidavit to the proposed affidavit in opposition that may be filed by this veterinary department list accordingly on 15th.
Obliged.
24.
It's one nice.
Yes, Mr. Pathak.
My lord, this was having a limited prayer, my lord, regarding transfer allowances, my lord. He was, my lord, initially posted from West Bengal to Guwahati on own request, and for that he was obviously not entitled to TA and joining time. But then shortly within joining at Guwahati, my lord, he was again posted to Tezpur. So the request was made, my lord, that my earlier transfer by which I had come to Guwahati and then went to Tezpur should be all treated as a public interest transfer and not a own request transfer. The reply has been filed, my lord. They are basically saying that as if I am aggrieved by my transfer. I am not aggrieved by my transfer that I have been again put from Guwahati to Tezpur. My only thing is that, my lord, I am claiming that the allowance, which is not a huge amount also, but then it is either entitled.
What does the rules say?
My lord, the rule says that, my lord, if it is own request, you are not allowed to get any, my lord, TA and allowances.
That is from Calcutta to Guwahati.
Guwahati. But
You are asking for the benefit from Guwahati to Tezpur.
No, I'm asking from Kolkata to Guwahati because I could not serve it Guwahati. Immediately after posting at Guwahati, I was again put to Tezpur, my lord. So essentially my posting in Guwahati was nullified.
Who's for the respondent here? CGC?
Lord, the UK Goswami.
CGC. All right, Mr. B. Pathak for the petitioner, none appears for the respondent counsel.
This may record my name. I'll inform it a group process. Although this matter has not been allotted to me.
Don't tell us all this. We are not concerned. who
Yes,
is
I
allotted,
understand,
what
understand.
matter. Or you have difficulty, you give it to us, we'll start allotting matters.
No, that's fine, Lordship.
Then, all right, Mr. CKS Borua appears for the as a learner, as a CGC for the respondent. He submits that Mr. UK Goswami, learned CGC, has been entrusted with the matter, who however not available in court today. Matter therefore stands deferred to be listed next week. You'll have it next week?
My lord, next.
Next week.
50th.
Please, your lordship, my lord. This requisition is pertaining to dismissal from service, lordship, and despite the repeated order of this honorable court, lordship, the respondent is free to file their affidavit, lordship.
The thing is that, lordship, we have received the various comments in regard to the matter, lordship. So, lordship, I require one
In fact-
opportunity to file our
In
affidavit,
fact,
lordship.
lordship, on 22nd of November, lordship, 24, lordship, this honorable court directed to produce the record also, lordship. Neither affidavit
So
nor
we'll
record.
issue rule, let the matter come up for hearing, let the records be produced. If they file, they file. If they don't file, it's a question of dismissal from service. Appeal also dismissed,
Appeal, lordship, they have nothing.
not preferred. Why?
No, lordship, appeal preferred, lordship, they have not taken any decision, lordship.
What is the decision? At least give us that.
No,
Stoppage of,
What is the decision in the appeal? If any.
no decision has been taken, lordship.
Then
Nothing to. And he is fast approaching his job superannuation, lordship. This is the difficulty, lordship.
matter be listed on 15th. On which date the learned CGC additional government advocate
lordship.
will obtain instructions as to the status of the appeal preferred by the writ petitioner against the order of dismissal passed by the disciplinary authority.
Lordship.
The learned counsel for the petitioner submits that the affidavit that the appeal filed by the petitioner has remained pending. List on 15th. Give us instruction what is
Lordship, basically, in regard to appeal, lordship, the petitioner preferred an appeal. And lordship, Home and Political Department through Assam, the said appeal petition was forwarded to the Commissioner Secretary for taking the needful action as the state government is the appellate authority in respect. Otherwise, lordship, in respect of Inspector of General as per schedule so and so, Rule 66. So after that, lordship, what has happened in regard to the appeal, lordship, that is also missing in the paras. So let me get the updated instruction.
15th September.
Deeply.
Awesome.
May please, your lordship. Lordship, in this matter, the respondent were supposed to file the affidavit.
And I'm praying for 2 weeks, I'll file the affidavit. We have the instructions.
What is your prayer here? You are agreed by?
My lord, I was suspended on 18/1. Thereafter, my lord, I approached this honorable court for revocation of my suspension order for not doing the periodical review. Then, my lord, the respondent, by placing a written instruction, stated that on 12/7/2024, the inquiry report has been submitted and they are going to impose penalty upon me. Annexure 2, page 18. Thereafter, my lord, they have issued notice to appear before the inquiry authority. Then I appeared and subsequently, my lord, they have submitted a second inquiry report now. That is on, my lord, 29/8/2024. Now, our stand is that, my lord, there cannot be two inquiry arising out of one disciplinary proceeding. So I.
Where is that second inquiry?
My lord.
What is that page number 18?
Page number 18 is the written instruction. My lord, this is the second round of litigation, my lord. Page 18, my lord, that was placed, my lord, during my lord, first round of litigation. My lord, may kindly see, my lord, point number 9. My lord.
Inquiry report submitted.
Yes. And they are going to impose punishment. So subsequently, my lord, on that day, my lord, my prayer for revocation of my lord, the suspension order could not be considered due to this instruction. Thereafter, my lord, on the my lord,
23.
23, my lord. My lord, informed you that an inquiry into the charges framed against you is to be held on 13/8/2020, 2024.
You're not getting instructions, call the records. What are you doing?
Our instructions are there, my lord. We'll file affidavit. Just 2 more
What
weeks.
instructions? What have you done? How many inquiries are you holding?
As per our instruction, my lord, there was just one proceeding. The other one that learned counsel is referring, my lord, that was just a draft, my lord. So, my lord, let us bring that on record, my lord. We'll file it in 2 weeks. My lord.
No, bring it on by this week. File it by this
we'll
week.
file. We'll file.
We are having the matter next week. List on 10th.
10th. File.
Enabling the respondent counsel. Which department is this?
PHC, my lord.
PHC department. To file their affidavit as it is submitted that the instructions have been received. Learned counsel. Your Mr.
M. Dotto, my lord.
M. Dotto appears for the writ petitioner. List on 10th of September.
10th is, my lord, day after.
Oh, sorry. 17th.
Obliged, my lord. Obliged. My lord, there is an interim order that may kindly continue.
Interim order
Yes.
for
My lord, regarding my lord status quo, maintaining of status quo on the second inquiry.
interim order, if any, passed will continue till the next date fixed.
On deeply. Obliged.
27th. Yes.
Lordship is related to Lordship appointment of the Gao Pradhan Lordship. Last occasion, the opposite party.
Appellate authority, what happened?
I have taken instruction, Lordship, that appeal, hearing of the appeal is concluded, only for, reserved for order, Lordship. Within 10 days, they will pass order, Lordship.
Within 10 days.
Within 10 days.
Fixed date, Lordship. That is a fixed date.
Learned counsel for the MS Nargis appears for the petitioner. Mr. Dotto appears for respondent number
1 and 2, Lordship.
1 and 2. MS U Sharma for
Respondent 3, 4, and 5.
3, 4, and 5. Mr. Dotto on instruction submits that the appellate authority has concluded the hearing and the order is reserved. He submits that the matter be listed after 2 weeks, by which time the order should be delivered.
Lordship.
Fixed date.
List this matter again after 2 weeks. List on 26th
Lordship.
of September.
Lordship.
Obliged.
Item 28.
May I please.
This is for appointment on arbitrator, my lord. Here, what happened, my lord, to our notice also, they have replied, to which they said that we should go for arbitration. And we file a suit. They have taken a plea in the written statement that there is arbitration agreement. So we withdraw the suit, my lord. I don't
So
think there is any difficulty, my lord, for appointment or arbitrator. my
We
lord.
have filed a reply today, your lordship. Can it be on 10th of September?
Reply.
Yes, your lordship.
All right. Any difficulty on 10th, Mr. Saivola?
10th.
Mr. G. N. Sahiwala, seeking counsel assisted by Mr. M. Sahiwala, appears for the petitioner. The Mr.
J. Das.
J. Das appears for the respondent. Mr. Das submits that an affidavit has been filed today.
Yes, your lordship.
Accordingly, as agreed with by the counsel for the parties, list this matter on 10th of September.
Deeply obliged.
Registry will trace out the affidavit. Registry will connect the affidavit stated to be filed by the registry, by the respondent to the case records.
Deeply obliged.
May I plead the lordship? Matter listed before appropriate bench, lordship. Matter is related to civil bench 2, lordship.
Civil bench 2.
Yes, lordship.
Oh, matter be listed before appropriate bench as it is submitted that the matter pertains to civil bench within bracket Roman 2, not bracket Roman 2. Registry to list this matter before the appropriate bench.
Arguably.
Yeah, Lord, in this matter, my lord, an amount of rupees 4,47,753 was sought to be recovered from the pensionary benefits, my lord.
Why?
But as a excess payment, my lord. But in the meantime, my lord, the pension has been finalized, my lord. But we have not received the pension payment order, my lord. So, my lord, one week time.
We pray for some time before instruction.
Instruction is awaited.
So everyone is praying for, you are also praying for time.
My lord, in the meantime, finalize, my lord, pension.
What?
All right.
time-
It is submitted at the bar that pension claims of the writ petitioner have been finalized. However, the pension payment order is not yet being issued. Council
Not received, my lord.
not received by the petitioner accordingly. As agreed to, matter stands deferred to be listed again after 2 weeks.
Lordship.
Yes.
Lordship. Oblige.
All right. My lord, date may be fixed, my lord. There is an interim order also.
26th.
Lordship.
Interim
Interim
order.
order will continue till the next date fixed.
Right.
I think items 21 and 22. But here, Lordship may grant us 2 weeks time, my lord, for filing affidavit in the matter. Otherwise, in WPC 206624, this petition he has filed after retirement, my lord. He has been given some of the retirement benefits. Provisional pension, GPF, and other GIS have already been sanctioned, my lord. The rest, my lord, I have to take instruction and I'll file the affidavit in the meantime, my lord.
All right. At the request made by Mr. D. Nath, learned senior government advocate, praying for 2 weeks further time to complete his instruction, matter stands deferred. Yes,
Lordship, there is an interim order in this matter.
Mr. MP Sharma, appears for the
A. Chakraborty.
petitioner. What is the interim order?
Lordship, that the respondent authorities will not proceed with the disciplinary procedure. Order dated 9/4/2024, Lordship.
9/4.
Lordship, 2024.
Nine four.
Lordship, in item 22, Lordship.
Interim order passed on 9/4/2024 in WPC 2066 of 24 will continue. List accordingly.
I would like.
Item 31.
You'll have to refresh my memories. Again, it's been quite some time. Or can it be on 18th of September? 18th of September?
I may not be here. Lordships have heard the matter fully.
There were some
Only
judgments which were placed.
Two
Ah.
two judgments were placed. I just deal with them.
No, you're dealing with the judgments is okay, but
I'll give a brief summary of what we transpired.
only just to familiarize what were the issues.
Yes.
So,
We'll try to just do that, you know.
or 23rd, if it is 23rd, 25th.
Look, I have a little bit of problem that I will be available.
I can just refresh your mind today itself if your lordship is not having any other problem.
Then it has to be after we complete the list.
Oh, we have not list.
Then we can complete the list and then.
Yes, yes.
Or we were thinking of completing because Mr. Nayak will also have to perhaps give a reply. We wanted to complete it in one day and then try and deliver the judgment immediately.
Huh? You both have completed. And my learned friend, after reservation of judgment, he has filed 2 new cases. And I'll just deal with it and also give your lordship a brief idea. We'll wait, your lordship will.
Let us, you're not available on 18th. 18th, you're not available. September? The dockets were
Will be not be available.
not be available.
No, you're not till Puja.
Some
All right.
problem.
We'll try then at the end of the list today. We'll try.
As per last order, they were to clarify regarding the present grade of pay being paid to the petitioners. They are supposed to file an affidavit.
Who's for the finance? Finance. Yes, Mr. Nayak, any instructions here?
Lordship, in this matter, one of my colleague is appearing, Lordship. Today he is absent, Lordship. That is.
When?
Our board is appearing.
No, on different dates, different councils.
No,
will
he is
appear.
in the last few days, Lordship, he is appearing.
No, you had appeared earlier.
On
Mr. Gogoi had
28th,
appeared
I
earlier.
appeared.
Mr. Gogoi, yes. Mr. Gogoi appeared.
Mr. Cholia appeared earlier. Where is Mr. Gogoi?
And Lordship will take this method tomorrow or day after tomorrow, Lordship.
List on 10th.
10th, yes.
Mr. Nayak, additional AG, appears for the respondent, and State of Assam, and Mr. D. Bhattacharya for accountant. Mr. A. Bhattacharya for 6. List on 10th.
How was?
Appeal number 34.
Yes. This matter I'll be filing on Wakalatnama and perhaps records were called for and records has to be retrieved. Mr. Gupta was there, Harish Gupta.
Issue rule matters should come up for hearing.
And I have to.
All right. Mr. D. Gogoi, Learned Counsel, submits that he has been recently engaged in the matter. He seeks time to complete formalities in filing the power. List again after 2 weeks.
All right,
25.
No, please.
Yes.
Matter related to pensionary benefit to the husband of the petitioner lordship.
Mm.
So kindly, here is the last order lordship, 11/8/2025 lordship. Because not filed.
Yes.
Basically, lordship, here in this case, as part of last year lordship, that
Readings
is,
are complete. Readings complete here.
this affidavit filed,
All
only
right.
thing,
Matter
that,
be listed for admission hearing on 18th September.
18th September.
Hmm.
Oh, bad.
This pertains to anomaly in pay, my lord.
Hmm.
He was serving in the Assam Rifles earlier as a doctor, but then he came to deputation in CRPF. The last pay drawn in Assam Rifle, my lord, was a basic of 1,42,700 in pay level 13 in the pay matrix, my lord.
Hmm.
Now, after joining, my lord, in the CRPF is saying that this is a wrong fixation of pay and not as per the 7 CPC recommendation. And they are asking the Assam Rifles to correct it, my lord. As to how and what would be the correct, my lord, pay is also not very clearly indicated. They are just simply saying that, my lord, some other officers are getting lesser pay than him. And therefore, his pay also is to be revised. There's no great clarity in the affidavit also as per the pay level matrix is
Then
concerned.
readings are exchanged.
Readings are exchanged, my lord. However, Assam Rifles have not replied, my lord. Only CRP have replied.
What is the basis on which you are claiming the pay
My
protection?
lord, I had all along been working in the Assam Rifles. My
No,
pay,
with regard to what rules and notification?
my lord, 7 CPC, my lord. The pay is fixed as per 7 CPC, my lord. As per 7 CPC, my lord, I was in level 13. So my basic pay automatically came to 1,42,000, my lord.
While you were working in Assam Rifles.
Assam Rifles. But
Then
then in
you are-
2022, when I joined CRPF says that it needs to be revised and it is not in consonance with the 7 CPC. That particular communication, my lord, at page 30 does not even indicate, my lord, as to how and what should be the correct pay according
But
to
you
the
have
7
not
CPC.
arrayed Assam Rifles as
We have
a
made,
party?
we have made a party, my lord.
Accounts officer. Respondent to accounts officer.
Two, my lord.
No, only accounts officer,
My lord.
not the Assam Rifles.
No, this is the office that controls the pay and.
Whatever it may be, but the
other things.
direction has to go to Assam Rifles, if any.
This
So
is like
what is the CRPF saying?
See, as per our affidavit lordship, his pay fixation was wrongly, he was wrongly fixed, lordship. In page number 55 of our affidavit, paragraph 8, lordship. Paragraph 8. May I read, lordship?
Yes.
That in reply to the amendments made in the paragraph number 7 of writ petition, it is submitted that the petitioner herein entitled enlisted in Assam Rifles as assistant commandant in the pay scale of rupees 8,000 so and so plus other allowances from time to time on 5/11/2003. After completion of basic training, he remained posted in various offices of Assam Rifles. In between, the petitioner also remained on deputation with NSC, that is from so and so. the petitioner was promoted to the rank of Deputy Commandant SMO in the pay scale of rupees 15,600 to 39,100 plus GP rupees 6,600. And that is from 5/11/2007. The petitioner was further promoted to the rank of second in command in the pay scale of rupees 15,600 to 39,100 plus and GP rupees 7,600 in 5/11/2012. Thereafter, the petitioner was promoted to the rank of commandant in the pay scale of rupees 1,23,100 to 2,15,900 plus, GP rupees 8,700 and pay matrix level 13. That is on 5/11/16. As per extract of service legal received from Assam Rifles, the pay of petitioner was fixed in the promoted rank as rupees 1,23,100 on 5/11/2016. Prior to pay fixation to the rank of commandant, his pay was already fixed in revised pay scale in accordance with 7 Pay Commission. Subsequently, the pay of petitioner was again fixed in the promoted rank on 5/11/2016, in which his pay was fixed as rupees 1,34,500. He was allowed benefit to switch over and allowed accrual of annual increment in pre-revised scale on 1/7/16. Later on, the petitioner was relieved on transfer from Composite Hospital, Assam Rifles on 22/10/2018 and reported on Composite Hospital, CRPF, Guwahati on 3/11/2018. On receipt of LPC from Assam Rifles, it has been noticed that he was drawing basic pay rupees 1,42,700 as on 22/10/2018. Paying
That
level
is- that
13
is-
of pay
That is
matrix.
his last pay certificate.
Yes, Lordship, he was
He was
before
drawing that pay.
1,719. He was received the amount.
Well, my difficulty is that now they are saying in that same affidavit that some other officer is drawing lesser. So how his
How does
fix
it
was
matter?
paid, my lord, is not,
How does it
I'm
matter?
not privy to it, my lord, at all,
This is the last pay certificate.
my lord.
You have any objections, you consult with the Assam Rifles and find out why is he.
Yes, Assam Rifles sent the service record to the CRPF, Lordship. And on the basis of that record, CRPF submitted.
No, you come to page number 56, second subpara.
Yes, Lordship.
That according to you, he was drawing a pay which was comparatively more than a medical officer who joined similar rank
Yes, Lordship.
and similar pay in CRPF.
Yes.
Now, the employees, it differs from employee to employee,
My lord,
what pay protection they got,
my lord, including increments, my lord.
increments, etc. Now, in one particular rank, there can be different pay grades or pay metrics. If there is a doubt, according to you, his pay was wrongly fixed by the Assam Rifles, isn't it? That is your case.
Yes, Lordship.
So have you sought for any clarification from the Assam Rifles?
Assam Rifle, on the basis of that record, which is sent Assam Rifles to the CRPF,
No, no.
Lordship, his service record.
It is not that you have referred to the pay grid to
Yes.
point out that he had to be in X grid, but he was placed in X1. It is not your case. Your case is all similar officers are drawing lesser pay, he is drawing a higher pay. So it is essentially something on the hinged on presumption. You have to make a specific query to the Assam Rifles why you're giving him higher pay when similar officers are drawing lesser pay. No such query was put. This is not the ground for, because you have accepted the last pay certificate.
Yes, Lordship. But after that, last pay certificate was from Assam Rifles.
That's right.
After that, when the record was Yes,
No, record
observed-
was called for.
Yes.
The only defect you can see is that other officers are drawing less. That is not a ground to withhold. Your only ground is that as per the pay commission, as per the pay fixation metrics,
Mm.
there'll be a pay fixation, it has to be worked out.
Kindly come to page 57, Lordship.
57, yes.
Second line from
Hmm.
the Assam Rifles had further approached Assistant Account Officer Pay and Account Officer MHS Shillong in respect of Assistant Account Officer Pay and Account Officer Shillong had intimated that the option for fixation of pay submitted by the petitioner was exercised on the date of his promotion, that is on 5/11/2016. But the benefit to switch over was applicable till 25/7/16. That the said option was to be exercised within 3 months of the date of notification, that is 25/7/2016 of the said rules. The contention of petitioner was that he had submitted his option for fixation of pay in the revised scale as per 7 CPC from the date of his promotion, that is from 5/11/16. After accrual of annual increment on 1/7/2016, accordance with DOPT OM number so and so dated 28/8/18 as per rules 5 of CCS revised pay rules 2016, in case where government servant has been placed in a higher grade pay or scale between 1st day of January 2016 and the date of notification of these rules on account of promotion or upgradation, the government servant may elect to switch over to the revised pay structure from the date of such promotion or upgradation as the case may be. As per CCS revised pay rules 2016, opportunity for revision of option to switch over to revised pay structure has been provided in accordance with Rule 5 and 6 of CCS rules 2016 to exercise the option to switch over the revised pay structure effected from 1/1/2016 as notified by the CCS rules 2016, and to say that the said option was to be exercised within 3 months from the date of notification, that is 25/7/2016 of the said rules. The rule 6(4) thereof provides that the option once exercised shall be final in accordance with so and so dated 12/12/2018. The competent authority had relaxed the stipulation contained in rule 6(4) of CCS rules 2016 that the central government employees who had already exercised their option to switch over to the revised pay structure as notified by the CCS rule 2016 shall be permitted another opportunity to revise their initial option in terms of Rule 5 and 6 thereof. The revision option shall be exercised within a period of 3 months from the date of issue of those orders.
This is on the basis of what some notification that exercise
Yes,
option has to be exercised within 3 months. Where is
Yes.
that notification?
that notification is on
There's a DOPT notification that is not enclosed, my lord, however.
is not enclosed. Within 3 months, you have to switch off
No, where is the notification?
that notification.
2018 even file kora nai. It's not on record. my lord. So I'll do one thing, it's like, because it's a case of pay, I'll prepare a chart and date wise, my lord, rank wise, how the pay is to progress and how it was fixed, my lord. I think that would throw easy and better light, my lord, on the matter.
Yes.
I'll give a chart, my lord, to that extent.
Counsel for the petitioner submits that he would like to place before the court the relevant charts and the pay metrics on the basis of which the petitioner has made claims for his pay protection. So let's this matter again. Sir, 2 weeks.
2 weeks, sir.
Ms. S. Borwa, then at CGC appears for the respondent.
Obliged.
May please, your lordship. It may be passed over for the day, my lord. It may be listed again any day next week.
None appears for the petitioner on call, Mr.
PJ Talukdar on behalf of Mr. Didas.
PJ Talukdar appears on behalf of Mr. T. Das. Matter stands passed over to be listed again next week.
Much obliged.
Forty-one and 42.
May I please, your lordship. You will kindly take up the item number 42 first.
42. Yes.
My lord, in this writ petition, I have challenged the order dated 6 September 2024, whereby a de novo inquiry a direction was given to initiate a de novo inquiry.
Where is that order?
My lord, Annexure B, page 21.
Annexure
B, page 21.
Yes.
The relevant portion is at paragraph 4 million. Whereas the inquiry officer, after completion of the inquiry, submitted the finding that the charges of serious misconduct and dereliction of duty against the charge officer, Sri Ajay Kumar Hindi, Inspector UB of Police, are not proved. Whereas the disciplinary authority perused the finding and found not to be satisfactory, as Sri Ajay Kumar Hindi, Inspector UB of Police, were apprehended by a trap team of Director of Vigilance and Anti-Corruption Assam for demanding bribe and accepting it through middleman Sri Mukhtar Hussain. Hence, the findings dated so-and-so is not accepted. The charges may be inquired afresh and de novo inquiry will be conducted. There is no material irregularity, my lord. And there is no provision for.
Where is the inquiry report?
Inquiry report, my lord, it was never served on me, my lord.
Any affidavits filed?
Yes, my lord. They have filed, my lord.
What is their ground?
Main ground is the page, my lord. Paragraph 10, my lord. Page 29. The second paragraph. May I read me? The deponent most humbly begs to state that the disciplinary authority is empowered under the provision of para 6.18.1 of the Manual of Departmental Proceeding either to set aside the whole inquiry and start a fresh inquiry de novo, or to set aside the inquiry from the stage of occurrence of irregularity in order to start afresh from that particular stage. The provision of para 6.18.1 of the Manual of Departmental Proceeding is reproduced herein below. Page 30 meter.
Yes.
Where the disciplinary authority on a contention raised by the person proceeded against or otherwise finds that any material irregularities have been committed and that they have caused or they may cause prejudice to the person charged, or such irregularities are likely to vitiate the proceeding, it will consider whether the whole inquiry should be set aside and a fresh inquiry started de novo, or whether the inquiry be set aside from the stage of occurrence of the irregularity and it be ordered to the started afresh from that.
Respondent, what do you say?
Lordship, we have filed the affidavit, but I think Lordship, the record is required, Lordship, to.
No, record means your ground, you have taken a
Yes.
stand that the manual says.
Manual, yes, Lordship, that.
If you read the manual, the extract properly, kindly
Lordship.
see what is stated there, page number
Lordship.
30.
Lordship.
any material irregularities have been committed
Lordship,
and they have caused
or they may
or
cause
may cause
prejudice to the person charged,
Ah,
or such irregularities are likely to vitiate the proceeding,
proceeding.
it will consider.
So it is only under these limited circumstances.
Yes,
that you
Lordship.
Go for a,
Lordship,
and there are judgments of
Yes,
Lordship,
this court
Lordship,
where it has been held that ordinarily de novo is not called for.
Lordship, I need to go through these judgments, Lordship.
there are several judgments.
Several judgments.
Lordship.
And there are
Lordship
Supreme
has
Court
passed
judgments.
recently
Yes.
one judgment, Lordship.
There are
Lordship.
Supreme Court judgments also,
Lordship.
which clarifies on how,
Lordship.
when de novo can be carried or cannot be.
Yes, Lordship.
Tell us when.
Lordship, next week.
Is there any
Lordship.
interim order?
Yes, my lord.
There is an interim order.
Yes, ma'am. Subject to the outcome.
No, de novo.
No,
Only
Lordship.
that much has been given.
What has happened to
Subject
the
to the,
de novo inquiry?
it's continuing, my lord.
Huh?
It's continuing.
It's continuing, Lordship.
Continuing.
Yes, Lordship.
It need to be state.
Lordship may fix any date next week, Lordship. I have no.
Then list again on 18th.
18th, Lordship.
No, next, you wanted next week,
Next week, Lordship.
11th. Because
Can it be on 12th, Lordship?
12th is a holiday.
Oh, Lordship. Then 15th, Lordship.
15th.
15th,
All right, 15th.
Lordship.
Because prima facie, it appears that
Lordship.
may not be possible to carry on de novo unless your records reveal otherwise.
Yes, Lordship.
And then the entire effort of undertaking a de novo inquiry will be frustrated.
Lordship.
So, right, as agreed to by counsel for parties, this matter again on 15th.
15th.
15th of September.
Yes. Obliged.
Deeply obliged, sir.
The petitioner was suspended when after he was reinstated on 22/11/24. But she has to get this remaining heir salary from 1/9/23, and also the period of the suspension, the regular salary. They have filed an affidavit, but it was not in detail. What amount I have to receive. The petitioner is
They have agreed
they
for
have
release.
they have given a very not detailed affidavit. Only
Who's for the respondent here? Is it
Tax-
Finance Department?
yes.
Yes, Finance Department is there. Please inform Finance Department.
Lordship.
Where is the affidavit?
Affidavit was filed on 21/8/25. The vague affidavit, only what I've stated in my petition, they have stated. Not about any heir salary.
Additional affidavit.
No, additional affidavit was filed by me. We have filed on 21/8/25.
Yes, Finance.
My lord, actually, Mr. Bigo is appearing in this matter, my lord.
Where
Right
is
now,
Mr. Bigo?
He's occupied in court number, my lord, 12, my lord.
He was imposed only the penalty of censure. After that, there is observation by the inquiry officer that first to join in the, then they take leave. This issue is settled. Only the area salary and regular salary when he was on suspension.
Have you given a detail of what is the amount to be received? Have you worked out the total amount entitled to you?
From 1/9 the salary till I have to take instruction then.
You give the detail that this is the amount for which, this is the amount that you are required to receive. Then we can dispose this matter off. Otherwise, we can still close it, directing them to examine and release.
They don't have problem. They don't.
But
they-
then you will again come back saying that this amount is not released, that
Yes,
amount
yes,
is not released. So you get the instructions properly. When can you get it?
Well, next week?
Next week. All right. Have it on 19th? 19th?
Yes.
Matter be listed again on 19th. By which date the respondent counsel will apprise the court the amount of salary payable to the petitioner during the period of she was under suspension.
And from 1/9/23.
And also with effect, this is the period of suspension.
No, before that also is yours.
And also arrear salary, which the petitioner claims with effect from
23.
1/9/2023. Mr. S.R. Gogoi for the petitioner, Mr. H. Borua for the respondents. List on 19th September.
Applies.
Item 44 and 45.
My lord, the first case is regarding the departmental proceeding, my lord. Once it was, my lord, inquired into, nothing was found. Thereafter, my lord, the government received the prosecution, my lord, papers, and they wanted to start it again, my lord. But in the meantime, my lord, the petitioner has already retired on 24/6/24. And the second case is, my lord, for the, my lord, regularizing the suspension period and to give him promotion. My lord.
Pleadings are complete.
These are complete, my lord.
All right. We'll keep it for admission hearing then.
Admission, my lord, I think.
Admission hearing on 18th.
18th, no, my lord, I should be out of, my lord. It may be next.
Then it will be in October.
My lord.
16th October. Well, released on 16th October for written hearing. As it is submitted that the matters are already fixed. The pleadings are complete in the matter. Yes, 16 October.
Item 46.
Lordship, this person died in the year, retired in the year 1996, Lordship. And subsequently he died in the year 2008. Some benefits have been paid, Lordship. Now his daughter-in-law is coming forward, Lordship, being the authorized representative. And in the meantime, Lordship, we have already paid the GPF amount, the gratuity and CPF amount, Lordship. And the payment of arrear pension, that is, process is going on.
None appears for the petitioner on call. Mr. P. Nayak, an additional AG, appearing for the.
I'm 1 to except 3, Lordship. 1 to 7, except 3.
1, 2, and
4, 5, 6, 7.
Submits that what has been released?
Lordship, so far as recent release is concerned, his gratuity amount has been released. And the PF amount has been released.
Gratuity and provident fund have been released, and the pension papers are under process and are likely to be released within a period of 4 weeks.
4 weeks, Lordship may not say, Lordship. It's a very old case, 1996 retired, Lordship. So we are.
It is under process, and steps are being taken for release of the same. In respect of the father-in-law, late father-in-law of the petitioner. Stop. Mr. D. Bhattacharya appears for the accountant. list this matter again after 4 weeks. Enabling the Standing Council, Finance to apprise the court.
GMC.
GMC. To apprise
Obliged.
the court on the next date. Okay.
May I please, the Lord?
Yes.
Also, in this case, the petitioner is aggrieved by order of dismissal. Pleadings already completed, and the petitioner also filed an appeal before the authority against the order of dismissal, but that's still pending.
The appeal is pending.
I have, yes, it is there, Lordship, but we don't have any. Lordship may then dispose of Lordship with a direction to process the appeal within a definite time frame.
But
Lordship.
whether it is pending or disposed of.
Lordship, that's what I don't have any information to that because I already have filed an affidavit. There is no mention of this, Lordship.
And Lordship may kindly peruse the order.
Because
dated-
if it is disposed of, then
Yes, Lordship, it is not there. Even if it is disposed of, they also have to impugn either way, Lordship.
no, that's a different issue. But
Then, Lordship,
you have not been served with a copy
No,
of the order.
no, it is not.
Lordship, then
have not
Lordship
communicated
may
with them.
fix it on 11th, Lordship, and in the meantime, I shall obtain the instruction.
11th.
Yes, Lordship.
For a moment, Lordship may kindly peruse order dated 21/4/2025 passed by your Lordship. In the last part of the order, no, your Lordship was pleased to observe that the records may be kept ready.
It's here, Lordship.
No, records all right.
It's
But
here.
if the appeal is pending.
Yes, that
departmental
particular
appeal,
account.
and you have filed it.
Yes.
Let the departmental
Yes,
appeal be first disposed of. Otherwise, it becomes redundant. It's a statutory appeal.
It's better.
Mr. P.P. Bodhakur appears for the petitioner and then Bhattacharya, additional senior government advocate, the respondent. The MS Bhattacharya submits that the status of the departmental appeal preferred by the petitioner is not available with her. She submits that the matter be listed on 11th of September.
Yes, Lordship.
On which date she will apprise the court about the status. List on 11th.
Can it be after one or next week, Lordship, 15th? 11th, I'll be out of session.
16th or 15th?
15th.
You want it on 15th? All right, 15th September.
Deeply obliged, Lord.
It pleases your Lordship. Lordship, there is a case where the petitioner was dismissed by disciplinary proceedings, Lordship, on charges of taking bribe. Thereafter, we preferred an appeal, Lordship. That was also dismissed. Now, respondent number 5 has filed an opposition, Lordship. And Lordship, the records, this case will be needed since it's a case of dismissal. Major punishment has been given.
What is your ground for challenge?
Lordship, in this case, the complainant, the main person who had given the bribe, died without adducing any evidence in the DP proceedings because his co-accused killed him before he could adduce any evidence. Thereafter, Lordship, there are no independent witnesses, even though the whole operation occurred inside the police premises, Lordship. Now, the petitioner has retired from service in 2019, Lordship. His dismissal has been given on 2023 and his appeal has been rejected in 2024. That is on 2/10/2024. That is also has been done perfunctorily, Lordship. That is on page 57-58.
Next rate of service, next rate of. Criminal case to ke khatam ho. Pending. The criminal case is also pending, Lordship, against the petitioner. It will stage of the
But there were other witnesses.
Yes.
There was only one other witness, that is Lordship Ansar Ali. Ansar Ali. He was behind Lordship and he did not see much, Lordship. And that person only killed the main complainant. The other persons, Lordship, were all from the vigilance team, Lordship. Sorry, this police personnel, Lordship.
Heard counsel for parties. Issue rule call for the reports, matter be listed for hearing.
Deeply applies.
Right.
49.
Lordship, can the matter be taken up after some time, your Lordship, after the lunch?
Well, here, Lordship has directed us to have the records. And our stand in the matter is that well, he was not considered because he doesn't come within the zone of consideration. There are 3 vacancies for the nomination for the year 25. No, Hori Prasad Bora. Hori Prasad Bora. Records have come. I need 1 day time to go through the record. I could not go through, and otherwise it's with us. On Thursday. On Thursday.
Thursday.
On Thursday.
Thursday?
On Thursday.
Released on Thursday. And a request of Mr. D. Nath, the senior government advocate, they submits that the reports have been received. That the peruse the same. We'd like to complete his instructions on these records. Mr. So-and-so learned counsel appears for the petitioner. Placed on Thursday, which is 11th.
11.
Yes, Mr. Biswas.
Lordship, in this case, readings are complete. I have filed my response to the affidavit in opposition. Mr. Knight is here.
What is the objection here?
The objection, because the fact is a bit different out here. What had happened is, an arbitrator was appointed by the respondent. And during the course of the proceeding, there was some biasness. An application was filed by the claimant, and thereafter he withdrew from the office. The arbitration proceeding was closed. Subsequently thereto, the respondents appointed him as one of the 3 arbitrators. Now, initially, what had happened, it was a sole arbitration, because as per the arbitration clause, I'll draw your lordships to that the arbitration clause says that, first of all, the proceeding would proceed through a sole arbitrator. If the parties fail to agree to a sole arbitrator, a 3 arbitration panel would be constituted for arbitral tribunal. In this case, when the sole arbitrator there was some issues with regard to his appointment around 12/5 with regard to that. Now, all said and done, the claimant participated in the proceeding, but during the course of the initial stage, before the exchange of pleadings, etc., could be completed, the application was filed with regard to biasness. A hearing was held, and he withdrew from office. Now, thereafter, they suddenly changed the tribunal from a single sole arbitration to a 3 arbitral tribunal. And they appointed that particular gentleman who was appointed as the sole arbitrator as their nominee arbitrator. So against this, we are there because the procedure is totally being deviated from. Because it is not a case, though their stand is that because of our raising our objection to his appointment, with his biasness, there is a failure in the sole arbitrator, which is not the fact, because they could have easily appointed another person to that. And we participated in the proceeding. It is not that we did not agree, but changing the nature of the arbitral tribunal and again reappointing the same person as their nominee arbitrator raises a question with regard to the neutrality of the tribunal that may be constituted. Now, I'll take your lordship.
Where is the arbitration clause?
Yes, your lordship. The arbitration clause, your lordship will find at page 120. If your lordship is page 120, clause 20. If I may read out, your lordship. Number A, in case of dispute or differences arising between the employer and the domestic contractor relating to any matters arising out of or connected with this agreement, such disputes or difference shall be settled in accordance with the Arbitration Conciliation Act 1996. Now, this is important. The parties shall make effort to agree on a sole arbitrator, and only if such attempt does not succeed, that the arbitral tribunal consisting 3 arbitrations, 1 each appointed by the employer and the contractor, and the third to be chosen by the 2 arbitrators to act as a presiding, shall be considered. In case of failure of the 2 arbitrators appointed by the to reach a consensus within a period of 30 days from the appointment, the arbitrator appointed subsequently, the presiding arbitrator shall be appointed jointly by the employer and the contractor. So these are the clauses here. Now, Section 21 notice was sent by us at page 176, your lordship. Annexure 9, Annexure N, sorry.
Annexure,
Annexure N, your lordship.
page.
Page 176. Now, your lordship will find after, and we had raised our demand with regard to the various claims, and those are reflected in page 184. We have raised the claims which we need to adjudicate before the arbitral tribunal. Subsequent thereto, your lordship will find at Q annexure Q1 is the letter by which the respondent appointed one Vanikanta Das, a former secretary of the government of Assam PWD, as an arbitrator for working for being the sole arbitrator. Now, here your lordship will find this letter, there is a dispute with regard to this also, that this letter was addressed to the chief engineer by the undersecretary, whereby he was selected, and thereafter this was communicated to us by annexure Q2 on 23rd of February 24 by the chief engineer regarding the appointment. Now, at the bottom, your lordship will find that here it was specifically stated that you are hereby required to render, at the last part of this, required to render your views and comments upon appointment of Sri Vanikanta Das as the sole arbitrator, or to constitute an arbitral tribunal consisting of 3 arbitrators. You were requested to respond as earliest. Now, although by the order dated annexure R is at page 195, is the order passed by the chief engineer, whereby the nominee was appointed formally. But the thing remains, your lordship, that on 26/2/24, when this order was passed, our consent, which was sought for on the earlier occasion, was not on record, because that was submitted by us on 26th itself at page annexure S at page 196. It is dated 26/2/24. This was
You were intimated on 23rd.
We were intimated on 23rd.
Appointment on 26th.
26th. And the letter which we sent to them on 26/2 was received by them on 28th. At the bottom, your lordship will find the seal of receipt. So even prior to our consent, he was appointed. In spite of that, once the claimant received the notice from the arbitrator to appear before him, the claimant appeared, and on annexure I at page 197 is the application by which the claimant raised objections with regard to the partiality, etc., with regard of the arbitrator.
When was this filed?
This was filed, your lordship, because it is reflected on the, if I may just read out here, the date is, I think it is on 9th of April 24, your lordship, as per the affidavit at page 201. Now, here, in the meantime, the arbitrator had even issued a notice with regard to the first sitting. Now, here we raised our objection. If I may read out the objection which was filed at page 197, that this arbitral tribunal was constituted by the respondent on such and such, as the aforesaid letter constituting was issued even prior to the receipt of any consent letter from the claimant, although as per the prescribed procedure for constitution of an arbitral tribunal to dispute under reference such and such, the agreement with this, he has raised the objection with regard to all this, and the first sitting was held, your lordship will find at page 198, para 3, that thereafter, when the first sitting of the arbitral tribunal was held on 20th of March 24, pursuant to the notice issued by the arbitral tribunal on 28th of February 24, the claimant's representative such and such engaged counsel were shocked and dismayed by the following events. There were some narrations with regard to some incidents which transpired during the said sitting, which gave a justifiable doubt and reasonable doubt about the impartiality of the sole arbitrator, and that fact has been stated in para 4 at page 199. Now, after that, your lordship, the order is passed by the said sole arbitrator. Your lordship will find annexure X at page 209. This is passed by the sole arbitrator, the said person who was appointed even before our consent was received here. And at the last part of the order, which is at page 212, the bottom of para 9, he makes the following observations. Finally, the arbitral tribunal feels that as the petitioner claimant has no trust upon the arbitral tribunal and has raised many unpleasant and unwarranted comments upon the independence and impartiality of the sole arbitrator without any justification before the submission of SOC, and hearing of this continuing process may lead to more controversy and dispute to the proceeding, and therefore I terminate the proceeding here and close the arbitral constituted by the such and such. So this was closed. The earlier proceeding with the arbitral tribunal came to an end, and thereafter the petitioner as the claimant again on 14/5/24 annexure Y sought for a substituted arbitrator in place of this, the person who has withdrawn from office. So all along we were, with regard to a sole arbitrator, we have not said that it was not going to go for a sole arbitrator. Even the proceedings, though they had sought for our consent, has been bypassed and he was appointed. And that was there. And this also again we have filed. Now their stand is, as they have already appointed the said person as one of the members of the 3-panel arbitration tribunal, this case cannot be argued before this honorable court, because they have already followed the procedure, which my respectful submission is, it has not been done, because on 23rd, the thing was very clear. First, a sole arbitrator. If there is a failure to appoint, then this. We had never disputed with regard to the sole arbitrator, but the appointment of the person who was made a sole arbitrator was done without following without taking our consent. And this has come to this. Now, this is the stand, and before this, there have been some other applications, some documents they have filed saying that we had been intimated and a panel list has been given, but no panel list also has been provided to us. And panel lists have been thrown upon by the various courts, saying that selective panels may not be given to a person until and unless the entire panel is provided to the person, merely supplying a few persons from their panel.
But what is the scope of raising this ground of the biasness of the arbitrator?
Grounds?
No. What are the parameters of raising the biasness?
The parameters with regard to impartiality, etc., is there. But That has chapter is closed to the extent that he has himself withdrawn. Now, what I am saying before your lordship is, before they proceed to the 3-panel arbiter tribunal, the first recourse was always to the sole arbitrator. We have not objected to an appointment of a sole arbitrator.
It will come back at one.
Yes,
Lordship, this matter will require some hearing, Lordship. Instead of today, Lordship will fix a date and Lordship will pick up the entire matter.
Of course, it will require a hearing.
yes.
When do you want it?
Any date, your lordship.
After vacation,
He wants it after vacation, but
Yes. The matter will, yes, the issues here will require some hearing. Both the councils are agreed that the matter be listed on 16th of October.
After vacation, Lord.
16th October.
The Lordship. 16th October, yes.
16th October.
Obliged.
Kindly peruse second page, Lordship, note 3.
Date of filing application.
Yes, Lordship. And in the order, Lordship, that is reflected, that is page 11, Lordship, paragraph 4
Of your affidavit.
of the contempt petition. Page 11, Lordship, paragraph 4.
In the judgment.
Yes, Lordship. Though the petitioner got married so she was divorced and had thereafter lived with her mother. Upon the death of her mother on 17/10/2018, the petitioner had applied for family pension.
How old is the petitioner? Well, she was a minor.
No, Lordship, he was divorced daughter, right?
Now 37.
So she filed application on 17/10/2018 as per notification from the date of filing of the application or publication of the notification. So on the basis of date of publication of notification 9/8/2018, we have issued the pension payment order.
That's it then. Complied with.
Yes.
We have to see the notification.
That is government notification, my lord.
There, you have a look.
I have copy, my lord.
Give it to. Yes.
No, after some time, my senior. Yes.
Enough. We had given you time till 4 o'clock. Third counsel for the parties, this contempt petition will file. Alleging willful disobedience of the judgment and order dated 3/0/11/2021. Verify. The petitioner who was the divorced sister and dependent on her deceased mother was held to be entitled to family pension, subject to the condition that the authorities may be satisfied on the dependency factor by incorporating additional queries as may be deemed fit and proper. So the learned para, the counsel representing the accountant general.
Yes, Lordship.
Has filed an affidavit. We submit that. Where is the averment in your affidavit?
Lordship, page 28, paragraph 4 and 5.
In the said affidavit. The office of the accountant general had authorized family pension payment order bearing number so and so by the letter number so and so, and subsequently revised family pension orders authority addressed to the Treasury Officer Jorhat to make necessary payment. Copy of the same was also sent to the petitioner in a residential address. According to the respondents, the pension is applicable with effect from 3004-2019, that is from the date of application in terms of government notification number so and so, dated 9/8/2018. All this in para 28, page 28 of the affidavit. So, Learned Counsel for the respondent, Accountant General, has placed before the court the notification dated 9th of August 2018 to submit that is by this notification, the Assam Services Pension Rules to be amended. And Rule 143 was amended. And after note 1, note 2, 3, and 2, 3, 4, and 5, note 2, note 3, note 4, and note 5 were inserted. Step. For the purposes of the present proceedings, note 3 is relevant, and therefore the same is extracted below note 3. Extract. So there is a note be safe, which that Rule 143 as it stood amended with effect from 9th of August 2018. Prescribes payment of family pension from the date of filing the application by the claimant or from the date of coming into force of this notification, whichever is later. Stop. This requirement is subject to the fact that there are no minor children in the family. Stop. But admittedly, in the present proceedings, the petitioner was initially married off and then subsequently divorced and was dependent on her late mother. So therefore, in terms of note 3, the date on which the application was submitted, namely where is the submission of the application?
Lordship, paragraph 4, respected Lordship, in the judgment.
Paragraph 4. But when did she submit? When was the application submitted?
6/8/2019.
Where have you stated it?
From this.
From the pleadings available, it seems that the petitioner had submitted the application after that. It's not stated anywhere. That the claim of the pension, family pension was pursuant to the demise of the mother of the petitioner on 17/10/2018, whereafter she had applied for family pension, DCRG, and other retirement benefits. So the same now stood considered by issuance of the family pension order from the date of her application for release of the family pension. Stop. Under such circumstances, we find that the directions contained in the order dated so and so have since been complied with. Therefore, the court at this stage does not wish to proceed any further with the contempt proceedings. Accordingly, the same stands closed. Disposed.
Pending item 14.
My lord. Finance secretary cooperative.
Subject one আছে রে।
Ashif, here the direction was to give the benefits of opendas to the petitioner because they were similar. Now my learned friend has said that there is a proposal that is being sent to the finance department, Lordship. So Lordship, I will just seek 10 days time, Lordship, to get the instruction based on what is the status of the proposal, Lordship.
Yes.
My lord.
Mr. H. Aliha, Learned Study Council, final submits that he would like to complete his instructions in respect of the proposal submitted by the which department?
Soil and
Soil conservation.
Soil Conservation Department, Government of Assam, regarding the grant of benefit of minimum scale of pay
Yes.
to the petitioner. Stop. He prays for 2 weeks' time. Prayer mat is not objected to by the council for the petitioner. Accordingly, matter stands deferred to be listed after 2 weeks.
My lord, kindly date may be fixed. Can it be on 22, my lord? Second, wait a second.
Second will be just 2 weeks.
Then, my lord, then,
Let it
on-
be after vacation.
Lordship, immediately after the vacation, Lordship.
no, my lord, it will be too late, my lord. Already the case is
No, Lordship will.
24th, my lord. 24th.
Twenty-fourth. Like 24th.
Obliged, my lord.
Item 52.
Maybe little question. My lord, matter pertains to my lord selection and appointment of Constable GD in Central Armed Police Forces, my lord. Petitioners participated in the recruitment process in terms of the my lord recruitment notice dated 27/10/22, and they have cleared all the my lord recruitment process, my lord. All the segment clear, but finally result was declared on 28/23. Petitioner result was kept withheld due to mismatch of biometric data, my lord. Since then, they have not completed the verification. So our
Out of 7, I have received today instruction, present status of out of 7 petitioners, 2 have got appointment. And other petitioner number 3, 5 and 6, their reporters and headquarter for revision of result. And procedure is complete.
Who were appointed?
Petitioner number 4
Hmm.
and petitioner number 7.
They are
And
appointed.
yes, Lordship.
Okay.
And others petitioner number 3, 5 and 6, their verification reports sent for headquarter for revision of result. And from 2, present status not received today, Lordship.
my lord, by
3,
the
3, 5 and 6.
3, 5 and 6.
Hmm.
one.
Their verification complete and report was sent for revision of results to the headquarter lordship. 1 and 2, the status has not received now lordship.
My prayer, my prayer is that the petition may be disposed of, my lord, directing the authorities to complete the verification within time frame. Thereafter, if found eligible, their consequence may be made.
Yes,
Yes, it may be lordship.
heard learned counsel to be parties. This petition is filed by the petitioners who had who in response to the advertisement dated 27/10/2022 for recruitment of constables GB in the CAPFs had applied for the selection process. The petitioners had successfully completed the computer-based examination, physical standard test, physical efficiency test, and medical examination. Stop. The results were declared by the Commission on 20/08/23, but the results of the petitioners were kept withheld due to mismatch of biometric data of the petitioners. The petitioners are agreed that their cases have not been examined and results have not been declared while other similarly situated persons whose names who were declared selected and in the results published on 20/08/2023 have already secured appointments. So pursuant to notice being issued, the respondents have filed their affidavits and rejoinder affidavits have also been filed by the petitioner. So today when the matter is called up, the learned CGC on instruction submits that petitioner number 4 and petitioner number 7's results were verified, and the errors / the mismatch which had occurred have been rectified and they have since been appointed. Petitioner number 3, 5, and 7, 3, 5, and 6.
3, 5, and 7.
Huh?
6, sorry.
3, 5, and 6. Their results are under verification, were verified and found to be correct.
It cannot, for revision, it is sent.
And
Verification report is sent.
And the basis of the verification report, the revision of the results, for revision of the results, the matter is sent to the headquarters.
Yes, lordship.
And their appointment orders are likely to be issued within a short date.
If they are found eligible, lordship.
No. What verification report?
That report not I have received, lordship.
So it must.
Verification complete and it is sent for revision.
Revision?
I have received this instruction.
No.
Revision of result.
Yes.
Yes.
Revision means what? Initially they were declared to be not selected.
Not withheld their withheld for mismatch of.
All right. Been
Yes,
sent for revision of the results.
Yes.
So far as petitioner number 1 and 2 are concerned, the instructions with regard to their status is not available with the petition, with the council. So, considering the fact that the process of revision has been undertaken against some of the petitioners, the court is of the view that at this stage, and 2 of the petitioners have already been appointed. This court is of the view that the writ petition can be closed with a direction to the respondent authority to expeditiously complete the process of verification. And thereafter, if it is found that the petitioners were wrongly denied their selection, the appropriate orders be passed by the respondent authority regarding the employment, regarding the selection and appointment of the writ petitioners. Since the writ petitioner number 4 and 7 are already appointed, this order will be in respect of, with regard to writ petitioners number 1, 2, 3, 5 and 7.
5 and 6.
5 and 6.
5 and 6. The writ petition accordingly stands closed. The respondents are directed to complete their verification and pass necessary orders of rectification or revision if, in respect of these petitioners, if they're found to be eligible for appointment in terms of the selection process. Let this exercise be completed within a period of 60 days. 60 days?
90 days, Lordship, 3 months.
Already 2 years gone, my lord.
90 days from the date of receipt of a certified copy of this order.
Obliged.
Writ petition accordingly stands disposed of.
Obliged.
I think 53.
By this application, I am seeking subsistence allowances, my lord, along with 2 increment for the year 2020 and 22 and 23, my lord. My lord, fact is that I was suspended during my service period, my lord, but subsequently I was reinstated. But my subsistence allowance for the period of 8/7/2022 to 16/3/2024 is pending, madam. No payment is paid to me, my lord.
What is the stand
Therefore,
of
this
the,
case, my
what is the stand of the respondents here?
lord,
What do the respondents say in their affidavit?
I will kindly say Annexer C, my lord.
What is the period for which you are asking?
Period, my lord, 20 months, 8 days, my lord.
Date. From which date?
Date, my lord, 8/7/2022 to 16/3/2024, my lord.
All right. That proposal has already been sent. Then,
My lord. Kindly see, my lord. Annexer C, my lord, is 13, my lord.
no, come to page number 22, affidavit.
22. Last page is 19, my lord.
No, affidavit.
Oh, affidavit. Yes.